associate in Denton's ACAS Law, and I advise employers and organizations on labor-related matters, as well as other things. But today we will be talking about, as the topic says, navigating pitfalls in workplace discrimination, harassment, and DEI. And before we dive into the topic, I thought it would be necessary to give, simple scenarios just so that you have that at the back of your mind. And at the end of the session, of course, we'll be happy to take any volunteers to answer questions, the question that I have in store. So the topic today is very relevant. It's not just a theoretical topic. It's quite relevant in today's world. It's something that employers and organizations are faced with. It sort of creates it's an everyday problem that creates a legal, operational, and people management challenges for employers. So the fact that we're discussing it today, I hope it will be very helpful. It will be very practical, I know for sure. I also hope it will be very helpful for our attendees today. So before we hear from the speakers, I thought it would be important to, as I said, just share two scenarios. The first one is, imagine a young professional, a young employee, I beg your pardon, who joins a company, an international organization. She joins the company, and shortly after joining, she receives unsolicited comments about her appearance, her looks by a senior colleague in the company. At first, she thinks it's harmless, and then gradually it becomes a bit more personal and uncomfortable for her. She feels uneasy about it, but she doesn't say anything. She doesn't complain to HR or to anybody because she thinks that it would label her as difficult or that reporting the issue might affect her career. Now, the question I have for you is, at what point does this become harassment? And what should an employee do in this situation? That's one scenario. Now, the other scenario is slightly, more straightforward in the sense that imagine you have two employees with similar experience, similar background, similar performance records, right? One constantly receives opportunities, whilst the other one is repeatedly overlooked. No one clearly explains why, but that's the situation. Now, the question I want you to have at the back of your mind is it discrimination? Is it unconscious bias? Or is it simply poor management? These are the types of difficult questions or difficult issues, I must say, that organizations today face. And today's session would seek to unpack these issues. We will be discussing, workplace discrimination, harassment, diversity, equity, and inclusion. Now, to guide us through these issues, we have two brilliant speakers who bring complementary perspective to this. Our first speaker is Professor Rosemary Danasi. She's a respected employment law scholar and HR professional with over 25 years of experience spanning academia, legal practice, and human resource management. She currently serves as a professor at the James Hope University Business School, and she's widely recognized for her work in employment law, labor relations, and workplace governance. We are delighted to have you here with us today. So without further ado, over to you.
Thank you, Alicia. Okay, thank you so much, Alicia, for that introduction. Good day, everybody. It's nice to be here with my distinguished colleague, Mr. Ose Opeku, and Alicia Adefarasin as the moderator, and all the participants that are here today. Yeah, my topic, let me start by sharing my screen for us to start. Okay, so yeah, thank you everyone. I'm going to be talking about navigating pitfalls in workplace discrimination, as the topic implies. I'll be looking at discrimination in the workplace, looking at the constitutional protections that we have, the legal framework, uh, as it were, against workplace discrimination in Nigeria, as well as judicial trends and DEI governance in Nigeria. Uh, we'll start by looking at what the objectives of this presentation is all about. By the end of this presentation, I would believe that participants will have a lot to take away. At the end of the presentation, we will understand the constitutional and statutory protections against workplace discrimination in Nigeria. And also we recognize the common forms of workplace discrimination and their legal implications, as well as statutory regulations that we must comply with as employers and business owners in Nigeria. And then we'll identify emerging judicial trends from the National Industrial Code of Nigeria and its enforcement of rules and laws. This is very, very important because whatever decision is taken by the NIC is automatically incorporated into everybody's contract of employment in Nigeria, and organizations must comply and be abreast with happenings and trends within the judicial space, as it were. And then we must also, at the end of it all, know how to apply practical strategies for promoting equity and meritocracy in recruitment and promotion. Because usually when we talk about workplace discrimination, actually a lot of times it starts from the very beginning, during the recruitment process. We will see this as we go on, and as well as during promotion process as well. So we'll apply practical strategies on how we can promote equity and meritocracy in recruitment and promotion, and how to turn compliance into a performance multiplier that drives employee retention and innovation. Because at the end of the day, we are going to be talking about DEI, diversity, equity, and inclusion. How do we make this work in the workplace? Is it just a legal compliance issue, or a governance issue as well? And then lastly, we understand the role of inclusive leadership, unconscious bias management, which Alicia alluded to earlier, and organizational culture in achieving effective DEI governance in the workplace. Now, we all hear about discrimination. Everybody talks about it. Oh, this one will say I've been discriminated against because of my gender, because of this, because of where I come from, and so on and so forth. Yes, that happens all the time. Now, it matters because when you're talking about building a culture of innovation, a culture where you talk about having an effective and efficient organization running. You're talking about increased productivity. You're talking about maintaining a good reputation, and so on and so forth. Workplace discrimination matter because it is something that creates a hostile work environment. It is something negative, and it is something that has to be dealt with. So it matters. It is no longer just merely an HR issue. It is simultaneously, as it were, a legal risk, because you know what happens when you have a litigation on your hands, when it comes to employee accusing the firm or the organization of discrimination. So it's a governance issue as well. It's a leadership responsibility because everything starts from the top. A leader could have, the leadership could have every nice thing on paper, on policy and everything, but then you have to walk the talk. You have to make it a governance issue. You have to ensure that you lead by example. Otherwise, it's just on paper, and then at the end of the day, you are not making it a governance issue, and you may not be able to achieve that ideal work space that we're talking about today. And then it's also a business sustainability issue, as it were, as well as a talent management challenge. So organizations that prevent discrimination are better positioned to attract, retain, and motivate talent while minimizing legal and reputational risk at the same time. So now I alluded to constitutional protection and statutory protection earlier on. We're now going to look at what the constitutional protection against workplace discrimination is. What does the Constitution provide against discrimination? Does it say discrimination in the workplace per se or generally? When you look at Section 42 of the Nigerian Constitution, it talks about discrimination generally. You should not be discriminated against under Section 42 because of the circumstances of your birth, because you're from one ethnic group or the other, because of your place of origin, your gender, your sex, religion, political opinion, and so on and so forth. So that gives it a broad definition, about the fact that people should not be discriminated on based on any protected characteristics whatsoever. Now you say you are discriminated against because, looking at the definition of discrimination, because you are treated differently or you are treated unfairly because of a particular protected characteristic. So under the Constitution, you have this protection. You have protection against inequality. The Constitution emphasizes fair treatment, equal opportunity. You see that in Section 17, especially when it comes to ensuring that there's equal pay for equal work. Now that's the constitutional framework, the constitutional protection against being treated unfairly or being discriminated against. Then we talk about the statutory protection. So the legal framework comprises of the constitutional protection and then other acts, including the Labor Act. Even though the Labor Act itself, contain relatively limited anti-discrimination provisions, when you compare to other jurisdictions, not just in more developed countries, but within Africa as well. And this is because, as we all know here, I'm assuming there are a lot of us here who are HR people and legal people. As we all know, our Labor Act has not been reviewed since it was first enacted in the 70s. So because of that, it does not address the common, the current realities in the world of work. The world of work has changed and it keeps changing. So because of that, when it comes to the broad meaning of or definition of discrimination, we often have to look at the Constitution as well as the National Industrial Court because of that alteration, the amendment in 2010 that empowered the National Industrial Court to adjudicate based on international labor standards as well as international best practices. So that has helped the workers in Nigeria to get better judgment, when matters get to that level. We'll see details as we go on. Then we have the HIV and AIDS Anti-Discrimination Act, that was enacted in 2014. A lot of times, when I talk to people in the industry and even in academia, a lot of people are not even aware that there's an act against discriminating against people who are living with HIV AIDS in Nigeria. And you will see later on when we look at some cases that people were actually, employees were dismissed, their contract of employment were terminated because of the fact that it tested positive for HIV. And some were outrightly not even employed because at the very beginning, during the recruitment stage, they tested positive for HIV. Then we also have another act, which is discrimination against persons with disabilities. That one was enacted in 2018, as well as the African Charter on Human and People's Rights. Ratification and Enforcement Act is the Nigerian law by virtue of Section 12 of the Nigerian Constitution. So that is the Nigerian legal framework. And then we have international standards. As I said earlier, the National Industrial Court has been empowered by virtue of Section 254 to ensure that they adjudicate based on international labor standards and international best practices. So for international conventions that against discrimination, we look at ILO Convention number 111, that's discrimination in employment and occupation, and then 190, my colleague will be talking more on that. It has to do with violence and harassment in the workplace. And then you have the UDHR as well, the International Covenant of Civil and Political Rights, then CEDAW. There are so many of them that the ILO always use when they are making decisions on cases that are before them. So the key message here is that Nigeria employment discrimination law is increasingly reflecting both domestic and international labor standards, and that has transformed Nigerian employment discrimination jurisprudence over the past decade. Before then, it was a bit difficult because of the fact that the Labor Act, did not really address these matters the way it ought to do in this modern world of work, or this current world of work. Now, there are many forms of workplace discrimination. We have discrimination based on gender. There's pregnancy discrimination. You would, some of us on this call will know that many women have also been dismissed or terminated from work because of the fact that they became pregnant, you know. So there's pregnancy, it's real, there's pregnancy discrimination, then disability discrimination, though there are not many cases here, but oftentimes we see people with disability coming out with various NGOs protesting that a lot of times they don't get employed because of their disability. Then you have religious discrimination, ethnicity, HIV/AIDS status, age discrimination, marital status, political opinion, trade union membership, and so on and so forth. You know, and then the discrimination could be direct, like what we've seen so far. Those are direct discrimination, and sometimes it could be indirect. It could just be a policy in the workplace, and the employer making that policy is not you know, advertently discriminating against anyone, but the mere fact that that policy is affecting certain types of people makes it an indirect kind of discrimination. For instance, if there's a new policy that says, okay, don't cover your head when you come to work, and then there are people who are Muslims, for instance, in that organization who normally cover their hair. So even though it's the new policy that just came in, unfortunately, it's going to affect a particular set of employees who are Muslims, or who, there are some Christians who also cover their hair as well. So then discrimination could be institutional, it could be systemic, you know, as it were. We'll see more examples as we go on. So now we'll start looking at the various forms of discrimination in the workplace. Now we'll start by looking at gender and pregnancy discrimination. Why on earth should someone discriminate somebody because the person is pregnant? You may want to ask, because that is the biological makeup of a woman. You must, I mean, if you decide to get married and have children, it is not the man that will have the babies. It is the woman that has been biologically prepared to have the baby. So it is something biological, it is something that has to happen. But unfortunately, we've seen cases where pregnant women were terminated, or even when they were on maternity leave, they were asked not to come back to work. So now when we talk about common workplace examples, you talk about unequal remuneration. When you talk about gender discrimination, that can come up, unequal remuneration. Women are being paid lower than men, even though they do the same work, you know, spend the same hours on the job. But because this person is a woman, is earning less than the counterpart who is a man. This is not to say that when we talk about gender issues, it's just only about women. Men can be discriminated against as well. But when you look at the statistics, you find that there's more discrimination against women in this regard. Then there's sometimes outright refusal to recruit women. This could also happen to men. You see some advertisement where they say, oh, if you are, you can only apply if you are a woman, or if you are a man. And even age discrimination is also another thing during recruitment. Sometimes the advert will say if you are over 25, don't apply. If you are over 30, don't apply, and so on and so forth. So that's outright direct age discrimination. Oftentimes, the Chartered Institute of Personnel Management, of which I'm a fellow, have had to come out to those organizations, to object to them putting it out there on the advertisement that if you are over this particular age, do not apply, or if you are below, do not apply, or if you are a woman, don't apply, or if you are a man, don't apply. Then you could also have denial of promotion, because of your gender. We've had instances where women are mainly the culprits, the victims here, who have been denied the promotion either because they were on maternity leave during the time of promotion. Because of that, they couldn't be part of that process. We've seen some live examples of that. Like I said earlier, pregnancy-related dismissal, even though there's maternity protection under Section 54 of the Labor Act, which gives pregnant women and women on maternity leave that immunity against dismissal, but we still have instances where employers have disregarded that provision and have gone ahead to terminate the contract of employment of these women. Then we also have instances of restriction of career opportunities because of the fact that you are a woman, the male counterparts will rise faster than his female counterpart because of certain issues like childbearing and so on and so forth. Then what are the consequences for an organization when you talk about all these forms of discrimination that we've talked about? There are definitely organizational consequences. We talk about litigation. We talk about low morale of staff. Then you talk about increased turnover, and of course, employer branding damage, because when you have litigation on your hands, these cases get to court. And then these days with social media, the matter will be all over the place. And you risk brand damage, reputational damage, because people will be talking about it that this organization is discriminating against his employee. That makes, even for the employees that are not leaving, they may not be leaving because they don't have opportunities out there, but the low morale will affect productivity, and subsequently business will not flow the way it ought to flow for that organization. Now, these are some of the cases we have for pregnancy-based discrimination. We have the case of Folake and the Incorporated Trustees of Clinton Health Access Initiative, Nigeria, and two others. And in this case, it was ruled that pregnancy-based termination equals gender discrimination. And then the woman was awarded punitive damages. A lot of times, the NIC does not ask for reinstatement because in the private sector, the courts normally do not ask for reinstatement as they do for public sector, or the public sector, but usually they award punitive damages in order to compensate the person that is concerned. So, and then we have the case of Omolola Olajide, who was said, this case was very well celebrated, where this young woman was said to have gotten pregnant before. I mean, she wasn't married, but she was pregnant. And according to Regulation 127 of the Police Act, once that happens, then you have to be dismissed from the police force. The matter went to court, and the the court ruled that it was unconstitutional under Section 42 of the Nigerian Constitution. So that particular regulation has to be expunged from the police act. And as we know, any law that is inconsistent with the Nigerian Constitution is null and void. So that was how she was reinstated. It was ruled as discriminatory because a policeman who impregnates a woman, while in service, is not given that punitive measure. It's only applicable to women. So because of that, it is discriminatory. And then she won that case at the end of the day. Then we have the case of Mrs. Amechi and Stan Queen Investment Limited. It was also a pregnancy-based termination. As soon as she announced that she was pregnant, she was asked to resign. She refused to resign, and then they decided that they will fire her by giving her a letter saying that firing was based on a redundancy, and the court said no, this is a pregnancy-based termination. So the takeaway here is that the NIC aggressively enforces international labor standards to penalize unfair corporate practices. You can see when you look at the details of these cases, you see that the NIC uses or adopts international best practices and international labor standards when they are adjudicating most of these cases, because that gives them the leverage, the leeway to be able to come up with something more in line with international standards, looking at the fact that our Labor Act does not really address many of these issues we are talking about. And then also we have disability, religious, and ethnicity discrimination, as we said in our introduction. We have the Disability Act, like I said earlier, though we don't have cases of people who are living with disabilities going to court and getting judgment in their favor yet, but we've seen a lot of them coming out, speaking out, demonstrating against the fact that they won't even be employed because they are disabled. And when you look at some of the scenarios of recruitment, for instance, you apply as a person who is disabled, who is on a wheelchair. You get to where you are supposed to be interviewed, for instance, if you have to do physical interview, and the office is on the second floor, third floor, and then you don't have an elevator there or a lift to take you to that floor. So right from the very beginning, that place is not meant for somebody like you, somebody who is on a wheelchair. And when you look at that kind of office environment, that kind of building, you see that they are not even complying with the Disability Act that says that every building must ensure that they have a way that people who are disabled, especially if you have physical disability, the inability to use your legs, for instance, you'll be able to navigate your way in that building. 5 years was given to all organizations to ensure that they comply, and that was in 2018. And there are many organizations today, many business places today that don't have those facilities put in place. So right from the very beginning, it is going to be very difficult for somebody with disability to work in that kind of environment. So sometimes you are even asked to, like in other climes, like in the United States here, for instance, you are even asked to provide reasonable accommodation when you fill forms, application forms. A lot of times you see places where they will tell you, oh, are you disabled? Do you need some special assistance? Do you need accommodation? And so on and so forth when you come in for your interview and all that, or when you get the job. Those things are stated there because the law makes these recruiters or employers to state those things. They are very important. Even the DEI issue is also addressed even at the point where you are applying. They will tell you we are an equal opportunity employer, we don't discriminate, and so on and so forth, because it is mandatory. You are mandated to do that. We don't have that yet in our system. Hopefully, as we go on, that will happen. And if we are serious enough to also amend our labor laws at both state and federal levels, then that will help a great deal for us to ensure that we address current realities, as it were, in the world of work. So then we talk about religion. I talked about dress codes earlier. Prayer accommodation. There are many organizations that accommodate prayer times for their employees. Like those who are Muslims, we have to pray 5 times a day, and part of the prayers will meet them at work. If you don't have that space, it will be difficult for your Muslim employees to pray at those times because they are set time prayers. Some organizations, big organizations, federal organizations like University of Lagos, for instance, they have churches on campus, they have the mosque on campus. Staff sometimes go in there to pray when they need to, but in most private organizations that are profit driven, they probably may not have that kind of accommodation. And many employees will not leave work and say, oh, I want to go and pray. So I don't know if we can say that is discrimination. As we go on, maybe during the question and answer time, we may discuss that further. And then you have ethnicity discrimination, tribal bias, nepotism, preferred treatment. A lot of times, like when we start talking about unconscious bias, we look at the fact that a lot of times we unconsciously, want to relate more with people that talk like us, people that look like us, people that come from the same place that we come from, and so on and so forth. So, but though there are many people who will discriminate outrightly because you are from a particular ethnic group or from a particular part of the country. And then nepotism, you are putting in people that people who are your friends, people who are related to you, as against people who are better qualified for those positions.
Hello, Prof. Just a quick time check. We have about 5 minutes left.
Oh my goodness. Okay, so thank you. Then we have HIV/AIDS discrimination. I talked about that earlier. This prohibits discrimination against persons living with or affected by HIV, including recruitment, promotion, training, transfer, and termination. A lot of times, employers will ask you to do some blood tests and without telling you that they are testing you for HIV. I remember somebody told me she went for the blood testing when she was being considered for a position. And then she had to ask, what kind of test are you doing from the technologies, the person who was doing the test? And he said, oh, I'm not supposed to tell you. And she said, you must tell me, because it is my right to know what kind of test you. Then eventually was able to even add that there was HIV tests. And she said, you need my consent for that. Though she went ahead and did the test and she got the job. Obviously, she didn't have HIV, but you are not supposed to, under this act, do that. You must not make your employment decision based on the fact that somebody has HIV or not. And the law also outlaws mandatory testing for HIV because it regards it as discriminatory. So there should be confidentiality according to this act. All your information must be kept private. There should not be compulsory HIV testing. We have some cases where even after employment, people are tested within the organization for HIV. The law says it must only be done if there's a law that says it should be done. So you are expected to also put this down in your handbook, in your policy, according to the National HIV and AIDS Workplace Policy of the Federal Republic of Nigeria. We have the case of Emmanuel Ejogu and Smindru Nigerian Limited, where this person was doing a routine HIV test, came out positive, and he was advised to leave and never return. And that matter went to court. The case of Georgina Ahamefule as well, and Adewumi Akinola and Ocean Marine Solutions Limited. So I'm trying to rush through now. Bias can occur, like I said, during recruitment and during promotions. We talk about biased job advertisement, then subjective shortlisting, stereotyped interview questions, then like me, bias, you don't have you don't have a particular criteria, a documented criteria that you use, when you are promoting people. It's subjective. If I like you, I like your face, then you'll be promoted. So when you talk about DEI, this is a no-no. You must have a way, that a laid down procedure, a laid down criteria by which you promote. Even when you talk about recruitment, when you are asking questions, when you constitute your panel, make sure it's a diverse panel. The questions are well thought out and well structured. It should not be subjective. Even the looking at CVs, a lot of people these days talk about ATS system, applicant tracking system, where it is AI that looks at this CV and then they put the criteria, that the job description thing, what the job entails, everything is put there. So it filters away those resumes that are not in line with what is stated before even humans see it. Even when humans want to see it, you may remove names, you may remove gender and things like that to ensure that you are very fair in what you are doing. So meritocracy is not achieved by good intention. It required objective systems, transparent processes, and accountable decision making, like I just said. Then the judicial trends from National Industrial Code, we've looked at some of the cases from the National Industrial Code, HIV cases, pregnancy-based cases. So you see that the NICN has increasingly demonstrated the willingness to protect employee dignity, apply international labor standards, and promote substantive justice over technicalities and so on and so forth. So the emerging judicial themes here are equality and fairness, procedural justice, good faith in employment decisions, human dignity in the workplace, and expanding reliance on international labor standards and international best practices. These are the decisions we talked about earlier, these cases that every employer should be aware of. This one, Emmanuel Ejegu's case, we talked about it earlier. And that's about HIV status, and then the Georgina case and Adewumi's case as well. So the NIC, like we said, uses international labor standards and international best practices in its adjudication. So Nigerian employers should anticipate increasing judicial scrutiny of discriminatory workplaces, so that at the end of the day, they look at it not just as legal compliance, but as a governance issue. You must put things in place to ensure that you conform to the laws against discrimination in the workplace. We also have global jurisprudence. We have cases from America, from the United Kingdom, that sought to also outlaw discrimination in the workplaces. They take things like this very seriously. And here, sometimes you have class actions, and when they award damages, it's a lot of money, unlike the small money that our courts in Nigeria awards to people who have brought these cases on. So now we want to move beyond compliance. Why does DEI matters? What are we talking about here? When you talk about legal compliance, you are saying what must employers do to ensure that they comply with the law? And then when you talk about DEI, you say, how can employers build workplaces where everyone has an equal opportunity to succeed? That is the crux of the matter. That is what is very important. When you have an effective DEI governance in place, that helps you to reduce discrimination risk, improve employee engagement, and increase innovation. It strengthens your decision making, and then that will help in your organizational improving or enhancing your organizational reputation and improving your business governance at the end of the day. So we have strategies that you can adopt, though I alluded to them earlier. We have must clearly define selection criteria. For instance, during recruitment, it must be competency-based, not because somebody is from a particular area, maybe from your place. You must have structured interviews, diverse interview panels, transparent promotion frameworks, documented decision-making, regular HR policy audits. Even though you have something in place now, you want to do some audits, maybe a quarterly, biannually or annually, to see whether it's actually working. And then you must also be abreast with NIC decisions. And then you must remember that you must be fair in everything you do. Then leadership, like I said earlier, is very important. It's not just about having those policies. You must lead by example, and it must be intentional. You must foster respect, encourage diverse perspective, listen actively, put in structures, put even your grievance procedure must reflect the fact that people should not be afraid to report discrimination in the workplace, and there should not be retaliation because somebody has reported discrimination, because the person who discriminated against the person is a big person, is an organ in the place. Everything must be done transparently, and um, there must be, you must challenge discriminatory behavior. You must not condone it. And then training, you must train your staff, especially people who make decisions, on how to ensure that they make use of the DEI principle in the workplace. So inclusive leadership builds trust before it builds performance. Then we talked about unconscious bias earlier.
Could
That's
you please
automatic
run
assumption or
through your
stereotypes that
slide?
influence decision
Apologies, I'm interrupting.
making without conscious awareness. So you must ensure that that is not there, because, like I said earlier, you want to you feel better with people who talk like you, do things like you, and so on. So for them, the halo effect, the horn effect, similarity bias, and gender stereotypes
Could you
must
please run
be
through the
reduced.
rest of your slides, please?
Okay,
Thank you
okay,
very
yeah,
much.
okay. I'm so sorry. So managing, then like you have to reduce bias. With these days, we talk about data-driven HR practices. Sorry, I just have to run through this accountability mechanism, structured decision making, and so on and so forth. So there should be cultural transformation and employee engagement. You know, when you talk about sustainable DI in the workplace, you know, it requires cultural change, as you can see on this slide. And so, what are the 5 key takeaways here? You must review discrimination policies regularly, ensure recruitment and promotion decisions are objective and transparent, train managers, strengthen leadership accountability, and so on and so forth. So the true measure of an organization's commitment to equality is not the policies it publishes, but the fairness it consistently demonstrates in every employment decision. So every recruitment decision, every promotion, every workplace policy, and every leadership action either strengthens or weakens workplace justice. So organizations that will thrive are those that move beyond compliance and intentionally build cultures where fairness, dignity, and inclusion are embedded in every employment decisions. Thank you so much for thank you so much for listening. I really do appreciate your patience. Thank you.
Thank you very much for this very practical and enlightening session. Thank you very, very much. Apologies, I had to rush you towards the end. The slides would definitely be shared with the participants. Thank you again. One thing that stood out to me in what you mentioned is, in what you said, is that sometimes discrimination is not that obvious. It's sometimes embedded in workplace systems, and you did quite an elaborate job and highlighting when that comes in. You spoke about how bias can creep in when into recruitment through subjective shortlisting criteria. You also mentioned, pregnancy-based termination. That was very, very practical and helpful. Thank you again. Now, without further ado, I'm going to introduce our second speaker. I believe he's still on the call.
Yes, I am.
Perfect, lovely. So our second speaker is Mr. Ose Opeku. He's the head of employment law, HR, and immigration practice at the Lawcrest LLP. Yes. He regularly advises multinational and local organizations on employment law, workplace investigation, and HR practices. as well as DEI frameworks and governance issues. His combination of legal and HR expertise make him particularly well placed to speak on today's topic. Thank you again. We look forward to your insights. Over to you, sir.
Thank you, Alicia. Am I able to share my screen now?
Yes, please go ahead.
Okay. Can you see my slides? Can you see my screen?
No, not yet. Just
Let me share my screen. Can you
and
see
for
it
the
now?
participants, please feel free to drop your questions in the chat box. And at the end of the session, we will, take each question elaborately. Thank you. Yes, we can see your screen.
Fantastic. Good afternoon, everyone. My name is Ose Okmeku. I'm a partner at Lawcrest LLP, and thank you, Alicia, for the introduction. Dr. Rosemary, thank you very much. I thoroughly enjoyed your session. It nicely ties in with the DIE aspect of what I was going to present. And I would say that with discrimination, the flip side of discrimination, like you rightly pointed out, is DEI governance. And we'll speak to that at some point in my presentation. Alicia, how many minutes do I have so I know how to pace myself?
You have 25 minutes, sir.
Interesting. You're giving me two very difficult topics that will take a day's session to present in 25 minutes. I'll try to see how I can manage the time. But if by the time I get to the 18 minutes, please let me know. Let me see how I can quickly speed up. Yeah.
No problem.
Thank you very much.
Right. Thank you.
So, these are basic introduction and all that, so I no need to go there. Let me go to the meat of it first. Just let me do this. So, the numbers tell the stories. It's quite damning. A STARE research in 2021, 64% of respondents had experienced workplace harassment and sexual harassment. Another research by MBA, IBA, and interestingly, I was part of that research in 2019 from the Nigerian Bar Association aspect of things. 1 in 3 women reported sexual harassment. 1 in 2 reported bullying. Now, the other research was carried out by University of Nigeria Enugu campus, and it was part of the sexual harassment awareness week they had, and was part of that project as well. Of all 53.5% people represented agree that they've been reported that they've been sexually harassed. And so harassment, bullying is obviously rife in our work spaces in Nigeria. So just quickly define some key concepts. I don't know why my this shouldn't be the case here. Okay, better, right. So there is no definitive definition of bullying under Nigerian law, but if you look at policy documents, the Nigerian National Policy on Safety, Security, and Violence-Free Schools in 2021, describe bullying as behavior repeated over time that intentionally inflicts injury or discomfort through physical contact, verbal attack, or psychological manipulation. Very interesting. But the question is then, what is harassment itself and that key concept? ILO 190 Article 1, that's Convention on Violence and Harassment in Workplace Convention, defines violence and harassment in the world of work to refer to a range of unacceptable behaviors, practices, or threats thereof, whether a single occurrence or repeated, that aim at result in physical, psychological, sexual, or economic harm, and includes gender-based harassment. Now, I mean, we can't really talk about this without looking at the legal framework, so I'll just quickly run through that. You have the Violence Against Persons Act, VAP, You have the ILO Convention 190, you have the National Industrial Code rules, the Constitution, of course, the one law. You have the Criminal Code and the Independent Corrupt Practices Act 2000. So the VAPE Act defines violence broadly to include any act or attempted act that causes or may cause physical, sexual, psychological, verbal, emotional, or economic. This law was meant to be domesticated by each state, and I think as Lagos State has domesticated, and other states have also domesticated it. Key sections there are Section 4, which prohibits willfully or knowingly placing the person in fear of physical injury. So it's not just the injury itself, but when you put somebody in the fear of injury, then that creates a situation where the person is not able to function. And that is why the whole aspect of health and safety is no longer just physical safety, but psychological and physical safety. So employers now have a triple obligation to provide a psychologically safe workplace and a physically safe workplace. I mean, if you take nothing away from this session, please remember that. Section 14 criminalizes emotional, verbal, and psychological abuse. Then Section 46 defines and prohibits harassment as a pattern of conduct that induces fear of harm or impairs a person's dignity. Convention 190, and I'll come back in details to that further down the presentation. The obligations of the employer. Like I said, there's an obligation to create a psychologically and physically safe world of work. And please note that again, that's another concept we delve deeper into world of work as opposed to place of work. If you recall, Dr. Rosemary used that a lot, the world of work. And that concept has shifted and created far more reaching applications on the employer. Have harassment policies in place, establish a report and redress mechanism, extend scope of limitation to interns and then ex-employees. Consumer judicial framework. The biggest flip and the biggest paradigm shift that ever happened in employment law in Nigeria was the Title III of the Constitution by including Section 254C, which gave the National Industrial Code exclusive jurisdiction, also extended its powers to apply international conventions that we have ratified without the need for domestication as laws, and where it has not been ratified, to apply them as best practices, and also gave National Industrial Code the powers to make rules and regulations on how it operates. So what National Industrial Code then did, well, did not define sexual harassment, but what it did was to provide guidance as to what needs to be proved to sustain a claim of sexual harassment. That in a roundabout way, defined sexual harassment. Cybercrime Act prohibits transmission of any material through a computer, that's Section 24, or network to bully, harass, or threaten another person, especially where it places them in fear of physical harm or death, violence or physical harm. So you can notice a trend across all the statutes. It's not just about the actual act, but the victim being placed in fear. So there's that element of it. So it's not enough to say, oh, I didn't do anything. But if you have placed that other person in a state of fear, where they anticipate that this person might actually do this, then this is a crime under the Cybercrime Act. Now, Independent Corrupt Practices Act. Very important provisions of Section 8 and 9 that talks about using your office to get benefit for yourself. And the benefits includes benefits in kind. And so this was a unique approach that the ICPC used in convicting Professor Cyril Osim from the head of Department of the University of Calabar in that case 2 years ago, yes, was sentenced for 2 years jail time and a fine. I do know that there was plans for him to appeal. Whether he did appeal, I think I'll follow up on that. It was very interesting how the ICPC used that as an umbrella section to file a suit against him, saying that he used its position, and we'll come to that again in balance of power scheme of things, to elicit benefits in kind, I mean, sexual favors from his students. So when bullying becomes physical, now, criminal code, under the criminal code, you can go for a case of assault, battery, and grievous bodily harm. Again, as with bullying or harassment, as the law states now in another act apart from criminal code, it doesn't have to become physical. What is a threat, and you of the view that you don't feel safe because of the attitude or behavior of this person, then it's something to look at. But when it becomes physical, it becomes a criminal offense under the criminal. Now, let's get to sexual harassment. I'm going to run through it, but the area I want to dwell on is the vicarious liability of employers for the acts of their employees. And while we are at it, Alicia, if Fatia can just put in there's a quick poll here where we're asking the questions if employers are vicariously liable for the act of their sexual harassment acts of their employees. So if you can quickly just fill out that poll, and then we'll have to get to that point and we'll discuss it. Thank you very much. Okay. Okay. Now, what is sexual harassment? By virtue of Article 1 of ILO Convention 190 and the VAPE Act Section 46 and Order 14, Rule 1 of the NIC Rules 2017, we can actually define sexual harassment as an unwanted, unpleasant, offensive, or threatening conduct of a sexual nature, distinguished from the sexual attention that is welcome and mutual. Also, that means the above is a summation of various laws. Welcome and mutual, a very key word. Welcome might not be mutual, but it's only not sexual harassment where it is welcome and mutual. Oh, okay. So, under Nigerian law, typically before now, there was no single legislation that actually defined sexual harassment or created obligations for our employers with respect to sexual harassment. What the National Industrial Code did earlier was to use CEDAW as a basis and international best practices in the two earlier cases of HJK Madrak and Microsoft and Abiodun and the Federal Reporting Council of Nigeria. So those cases said we'll deal with those cases when we get to the case review area. Were the first initial cases of sexual harassment in Nigeria. Very, very, very interested, and thanks to the National Industrial Code, being very forward thinking. But the important thing is, so I'll go back again to Section 254C. In 2019, after the Me Too issues and all that, IBA did a poll and a research and a survey, which Nigeria was involved. I was involved in that survey. And the damning outcome of that survey was the fact that there was a rot in terms of sexual harassment in the Bar Association worldwide. At that same time, precisely 2019, the ILO passed the Convention 190 And Convention 190 is the fastest ratified convention in the history of ILO. As at 2014, 444 countries had ratified the convention. Nigeria ratified it in 2023. And deposited its article of ratification with the Director General on the 7th of November 2023. By virtue of the status of ILO, it becomes operational 12 months after the deposit of ratification instruments. So by November 2024, it became operational. And by virtue of Section 245C, which says that the National Industrial Court in employment law issues and labor issues can apply ratified constitution as law. Typically, under Section 12 of the Constitution, to ratify any convention or treaties, it has to be first domesticated by Act of National Assembly. But National Industrial Court was given a blank check to apply conventions and treaties in two ways. If it's ratified, apply it as law. If it has not been ratified, apply it as international best practice, provided it is pleaded. So, I mean, sometimes National Industrial Court on its own apply it, but typically, as a litigant, you have to plead and prove the existence of that international best practice. And so, what then happens is that Convention 190 is a convention that every HR practitioner and lawyer should be very familiar with, because it changes the whole dynamics of how you approach sexual harassment from a governance point of view, from a law point of view, and from an organizational point of view. Now, the scope of this convention is what makes it very interesting. It applies to private and public sector, informal and formal sector, and introduces the concept of the world of work. And that becomes even more interesting when we deal with vicarious liability. Because the world of work is not just the workplace. And the world of work could be social event organized by organizations. It could be commuting to and from work. It could be anything connected to work in any way. Training outside the country, training outside the office, or those are classed as a world of work. Now, in terms of who applies to, employees, interns, ex-employees, volunteers, job seekers. I ask these days because when Rosemary was talking, she was talking about discrimination starting from the onset of the recruitment process. Now, harassment can actually start from the recruitment process. It also means that an employee who has left can bring a case of sexual discrimination, of sexual harassment. Now, forms of sexual harassment. And this is where the verbal and non-verbal, this is where we get it wrong a lot. And so unnecessary compliments about people's body and their shape, verbal comments that way. We assume that if you say to a woman, oh, you look very nice and all that, oh, I like your body, oh, God must have spent an extra time creating you. It can be obnoxious. If it's unwanted, so a no means no. It's not a culture of, oh, when she says no, she means yes, no. A no means no. So at that point, the policies must be very clear that if it's unaccepted, then it's a healthy practice that should stop. Non-verbal, ogling at people, making signs and all that of a sexual nature is harassment. A couple of years back in the UK, a judge was almost sent to jail because he went on the train system, on train rides, and would would take off his pants and flash for people, and it became quite a funny in a sort of way, but very serious, and the system took it seriously. But unfortunately, they couldn't get a conviction on that. Now, repeated unwelcome behavior that create an intimidating work environment makes it impossible for people to actually bring out their best. So repeated unwelcome sexual behavior. So you see some guys walking around grabbing their crotch, once again walking around and grab their crotch, or make some sexual inventive jokes, or just generally everything is sexualized, and it creates an environment where the other party is not able to function. And let's get it right. Let's get it clear here. This does not only affect the female gender, it affects the male gender. It affects the male gender. So you have this guy who is an ultra-Muslim or extreme Christian, and each time the lady comes near him, she has this low-cut camisole that leaves nothing to the imagination. And this person constantly complains. That is sexual harassment. So the same way a woman is harassed, a man can also be harassed. Also, in other crimes, it doesn't have to be cross-gender. It can be the same gender. So let's take our mind off that stereotype that sexual harassment only happens against women. Most times happens against women. No. I mean, in some countries, they actually have more men being sexually harassed than women. Physical, that's another area where we fall foul as a people culturally, because we're very tactile people. If someone is talking to you, he's punching you, talking about this and all that. It can be very invasive, and it can be very intimidating for some people, and it's unwanted. So, and there's I'm just looking at various manifestations and forms of sexual harassment. There's the quid pro quo, and like it says, it's something for something. That is usually when it comes to the balance of power. Most times it occurs around the balance of power. So the senior manager is recruiting, and then, okay, fine. Well, I think we should take you, but you have to come for dinner with me, and whatever happens from there. That's quid pro quo. Or senior manager is going to appraisals and you're due for promotion, but I can put in a good word for you if you play ball. That's balance of power again. Then cyber sexual harassment. This is usually sending sexual explicit pictures on the internet and stalking people and with other things on the internet. That can also come under the Cybercrime Act from the criminal aspect of things. And the beauty of 190, Convention 190, is that while the other acts always talks about the criminal aspect of things and the fine, which goes to the government at the end of the day, the Convention 190 is very clear. It is victim-centric. It has protection system in place, not just to compensate the victim, but to rehabilitate the victim. So that's why organizations need to have what they call employee assistance program. Things like whistleblowing policies, so people can report. And then there's a support for the victim.
Just a quick time check. We have about 5 minutes left.
Okay. Concept of power balance. I mean, I've discussed power balance quickly. So it's when you have control of power over someone and you use that as a means of getting sexual favors from that person. The complete handling framework. You have to build a robust sexual harassment policy. And I report multiple layers of reporting. It could be to the line managers, secure email reporting, representative, HR whistleblowing via anonymous lines. Alicia, do you have the result of the polls?
Yes, I believe we do.
What does it say?
Could you kindly share that with us? We had it up for a few minutes, but I think it's gone down now. Just give me a second. You can, we'll pull it up when we have it up. Just give us a minute.
Okay. Because that's very key. I want to go straight into that. The other slides we can always share. People can look through them.
I no longer have it on my screen. Fatia, is it possible to pull it up?
Or she can just read out for us if she has it.
Fatia, you're muted if you're trying to speak. But last I saw it was 43 to 57, but that was a while ago. It may
Okay,
have
57,
changed.
that's a, so 57 will say there's no vicarious liability.
Yes, and then 43% said yeah, answered yes to your question.
Okay, if Fatia has not been able to put that up, maybe we'll just go to that. So this was the poll. Are employers vicariously liable for sexual harassment perpetrated by the employee? Is a moving, how will I put it now? It's a bit of a transitional and fluid concept. Typically, an employer is only vicariously liable for an employee's wrongdoing, which is sexual harassment, if it's in the course of work. It's closely related to work and connected to work. Right. That was the position. And it was part of the decision in Morrison's supermarket against many claimants. That was the title of the case, Supreme Court decision in the UK. And Dubai and Million against Salah. That was that principle. However, because the word of work concept, instances where the activity of the employer is not closely related to the work still means
sorry, sir. Sorry to cut you off, sir. I've included the poll in the chat box.
Okay. Can you just read it out to us if it's possible?
Okay. So 46% answered yes and 54% answered no.
Right. Thank you very much. That means we're right on. So the only time that an employer will be vicariously liable for the sexual harassment act of an employee is where the employer has the policy or redress structure in place. The employer fails to investigate the complaint. The employer fails to follow its own policies. And a very recent case, I mean, even in Ejike Maduaka case, Justice Obaseki actually held that Microsoft International itself did not even follow its own policy when this lady reported to the international group. And that if that had happened in the US, they would have investigated the complaint and done something about it. Now, in a very recent case, 6th of June 2026, Vivian Chukwuebo against African Foundries Limited. She was awarded 2 years' salaries as compensation for sexual harassment because she complained. It was never investigated. 2 weeks later, her employment was terminated. So she brought a claim for sexual harassment and wrongful termination. Now, if you contrast this against with a Linda or no Jew against EcoPop, it is one thing to claim to throw in sexual harassment, but you have to prove it. It's regardless whether the company puts in a defense or not, you still have to prove the elements of sexual harassment. But so to answer the question, the employers will be vicariously liable for the sexual acts of their employees if they have failed in their duties to provide a psychologically and physically safe place of work. They do not have policies in place about reporting policies. There's no redress, and when they have their own policies, they refuse to follow their policies. In those cases, the employer will be vicariously liable. I don't know, Alisa, do I still have time?
If you can just run through the rest of your slide, we would very much appreciate it. Thank you.
Okay. So I mean, the word DEI has greatly transformed over the years. Initially, it was diversity, equality, and inclusion, but it's now diversity, equity, and inclusion. I mean, diversity is about the diverse nature of the workforce. which must represent ideally the geographical spread of where it is situated. And for me, it's one of the most difficult things to do in Nigeria, because if you're looking at ethnic diversity, you have over 250 ethnic groups in Nigeria. But I mean, for diversity's sake, you normally just streamline it to 3 major ethnic tribes and some major, some sub-major regions. For equity, that's very interesting, because like I love you, someone once said, once gave us that equality, make sure everybody has a pair of shoes. Oh, nobody has shoes here. Okay, everybody say, okay, everyone must have a pair of shoes. Equity comes to say, okay, everybody has a pair of shoes, but some people need size 7, some people need size 6, some people need size 10, some people need to get an American size 14. So equity looks at the individual need of each component, while equality looks at making sure that everybody is equal. Inclusion, inclusion is an extension of diversity, but diversity does not mean inclusion. So the organization can be diverse, but people are not included, especially in decision making, or their voices are not heard, and they don't feel like they belong to the organization. So why DEI? And Professor Rosemary touched on this earlier. There are legal reasons: compliance with anti-discrimination statutes and international conventions, why there should be diversity, equity, and inclusion. Moral reasons. I mean, fairness, dignity, and respect owed to every person in the workplace. And there's commercial reason: better performance, innovation, reputation through diverse talent, and especially with the Gen Z's retention of talents. And this was captured in the book by April Cox. April, the New Diversity, Equity, and Inclusion, DEI, Realities and Change, the HR Agenda 2021. Very interesting book.
Thirty seconds.
Okay, governance. Am I done? Government statutes, constitution, CEDAW, Lagos State Special Persons Law, HIV Anti-Criminal Law, Discrimination Against Persons with Disabilities Protection Act, Data Protection Act as well. How do you build a DEI policy? I mean, a DEI policy should intentionally cover some core areas: fair recruitment and promotion practices, reasonable accommodation for employees with disabilities, culture of open and diverse perspective communication, equal access to training and career development, harassment and bullying prevention policies, equal opportunities and discrimination practices. I mean, so the governance really is about the policies and mechanisms and the vision puts in place to ensure monitoring and accountability towards meeting its DEI targets. So DEI mapping, this is like, is an integral part of DEI, the process of identifying, assessing, and evaluating how the organization is performing on DEI. It looks at work demographics. So for argument's sake, is this workforce made up of people all who are above 50? Is this organization made up of people who are just between 18 and 30, or a mix of? That's kind of demographic it looks at. Is it mostly women or just men? Just like from demographic it looks at. Recruitment and hiring. What are the processes of recruitment and hiring? Does the criteria mean that a certain kind of people cannot get into the workforce? Career progression. How many people are of different demography in decision making or in implementation making or strategic team? Pay equity. How does the pay across? Is it a clear, fair assessment as to how people progress in their pay grade in terms of pay rise and all that? Training and accessibility. How is training carried out? How is it carried out? Does it make it impossible for a certain set of people to attend training, not to attend training, so don't get promoted? Is it such that the kind of bonding arrangement makes it unattractive to go into training and then they're not able to get promotion because they're not going to training?
Thank you very much.
Okay, I think I'll leave it at this. We'll share the slides and people can always have a look
Yes,
at it.
yes, that'll be great. Thank you, Mr. Opeku. Thank you very much. Very insightful. What I find particularly interesting is the connection between both presentations, right? So while discrimination, harassment, and DEI are often discussed separately, today somehow you both managed to show that they are fundamentally linked and they all relate to workplace culture, dignity, and accountability. And one thing that was underlined in both presentations was that policy matters, processes matters, and most importantly, and I think that was one thing you mentioned as well, is that leadership matters. Thank you again to Mr. Opeku and to Prof. Danasi. Now, I'm opening it up to the floor. If anybody has any questions, I was able to, I have a few questions, but participants, if you're here and you have any questions, please feel free to unmute, introduce yourself and ask your question. I don't see any hands up. Okay, I'll just go for mine first. I think mine is, first question I have, it's to Prof. Danasi. Oh, okay, so we have a question from Jesuye. Please feel free to unmute and ask your question.
Thank you very much. My name is Jesuye Oshe, and it's been a very interesting session. I think I joined about 30 minutes after it started, so I missed some things from the first presentation. My question is actually maybe a comment, and it's based on the first presentation. Now, we'll talk about discrimination in workplace, and I look at it vis-a-vis gender roles and what have you. And this particular issue keeps coming up when we talk about men getting paid higher or getting, higher salary than women based on being men. Then we look at the fact that when women are working, they usually leaves, especially if they want to be homely, if they want to raise their kids and what have you. So can we actually call that discrimination based on the inputs that both, I'm trying not to sound sexist here, based on the input that both the male and the female bring in to workplace. For the man, generally speaking, there's probably not that break in between like that of the woman. So do we see that as probably if I'm trying to not use the word reward, but reward for stability at the place of work rather than the woman's based on the desire to groom the house, groom the home and the children, all of that, based on that stability and not necessarily discrimination, as it were. Just my thoughts.
I don't know if I really got you there, Jesuye. What do you mean? You said, is it like the woman is being compensated for having babies and not getting the promotion, or what? I didn't quite get that question.
The other side to it that I see, I think, I've had that conversation with other people who are proud to know that the man is being compensated for the work stability that it brings in, or yes, for the work stability that it brings in vis-a-vis the woman. That's what's
okay, the man is being compensated. That's why he's getting promotion and he's getting more pay. Uh, well, I think the way I look at it is a bit different from the way you look at it. Pregnancy is a biological thing. Somebody has to make the babies, and that does not mean that the career has to suffer in the process. For instance, if somebody is pregnant, it's not supposed to be a disease, but there are certain things you need to do, go on, what do you call it now? Antenatal clinics, stuff like that. You can always, as an employer, you can always, or a boss, you can always get somebody to uh, act in her capacity while she's away for that period, when she has to do the needful. That does not mean because she's away for that short period, then she should be shortchanged, so to speak, from getting what is due to her, or she should be less paid because she's pregnant, as opposed to her male counterpart who is not pregnant. There are many women who are breadwinners today. It's gone are the days where, the man is the one who provides for everything, is the sole provider. Now, sometimes women are even the breadwinners. So you cannot say because of that biological arrangement, or what has been created by God, the woman should not be included in the promotion process, or while she's away on maternity leave, she should be employment should be terminated because now she has a baby. You think it's going to change a lot of things. It should not be like that. The law is there. When you're on maternity leave, you have maternity protection. Even when you come back, you still have like 2 hours during work time to nurse your baby. That does not mean that work will have to suffer because of that. So that's the way I look at it, and that's the way the law looks at it.
Thank you very much, JC O'Shea. Thank you. Any other questions from anyone? Okay, so I had a question, right? DEI is a hot topic, and it sounds like a very nice concept to have, but why should leadership take it serious in today's age? It's open to both of you, whichever one wants to jump in it.
Okay. I mean, so like with any other policy, without leadership buy-in, right, it doesn't fly. So for change to happen, for a cultural change to happen, there has to be leadership buy-in. And so, but the challenge we have in this climate, in the South, and not in the advanced countries, that we don't deal with statistics, don't deal with data. And so with DI mapping, right, organizations will tell you why it is important based on data, why you should have a diverse force, because it creates an innovative environment. Because most organizations thrive on innovation. And sometimes we see workers in, I'm looking for a job, but in most other places, people think twice before they work for an organization. So it's a selection process. And so you want to attract the best minds. You want to remain innovative. You want to remain competitive economically. And in other places, there's a legal requirement to be diverse. And there's branding points you get for being diverse. So really, from a legal point of view, from a commercial and economic point of view, from a sustainability point of view, right, from a profit point of view, there's every reason for any right-thinking leadership to embrace DEI.
Okay, yeah, DEI matters, Alicia. It's very, very important for when you talk about diversity, equity, and inclusion, right from recruitment process. You talk about workplace discrimination, right from the time you are recruiting through promotion, through performance management, succession planning, leadership development, employee engagement, even your grievance management procedure, you have to ensure that all the processes, shows that there's element of diversity, element of equity, as well as an element of inclusion. For instance, you set up a panel to interview prospective employees, people who you're trying to bring in to your establishment. That panel must be diverse. You don't bring people from just one ethnic group or one cultural group or people from one particular profession, and so on and so forth. It must be made up of a diverse group of people, because the more diverse a group or a panel, the better in terms of the way, the ideas they bring and the way they look at things. And then every step of the way, even the design of your questions, must show that element of unconscious bias or conscious bias is not there, is removed, because that's the only way you can ensure that you bring in that DI element in order for your that work environment to thrive and to remove the kind of discrimination, we are talking about, because we know the consequences. We talk about when you are not legally compliant, or you are not bringing in this DI friendly stuff. You a lot of times you have litigations on your hands. You have low morale in the workplace, and then it will also affect your succession planning as well as your business at the end of the day. So embedded equity in governance, is what is important, and that is why DEI, must be treated as a core business driver, not as a quick checklist. It must be part of your governance structure. You must, and from time to time, you must audit it, because what works now may not work in another year. So constant auditing, and then also aligning with judicial trends, all the decisions that are being taken by NIC and so on and so forth, being abreast with the laws. Many organizations their HR don't even know that there's an act against HIV discrimination. At least I've done that research, and I've seen that is out there. So that is why DI is very important, and it starts from leadership. You must walk the talk. Don't just have this policy there on paper. You must be seen to ensure that you concretize everything in practical terms.
Thank you. I have, I'm so conscious of time, but I have a question, right? Just generally based on the presentation, there's a gap that wasn't quite addressed. It's the fact that many organizations, right, have these anti-harassment policies, but we see the gap whereby the employee in the organization fails to take the right steps, or fails to report an incident. Why do you think there's that gap? Is it the culture that needs to be addressed? Is it a policy problem with the wording? In your experience, what do you think the issue is?
Right. I think it's a combination of everything you've mentioned. Right? There's the silent culture that you don't report. That's a cultural issue. We don't talk about these things because you feel you'll be shut down. Right? Yep. There's the other cultural aspect of respect for elders. Especially if from an older person, you don't tend not to report. Then there's also a cultural issue, again, of people minding their business. Because with reporting, it doesn't have to be the victim that must report. see something, say something. Right? So people don't even understand that. So it's also there's a lack of education on what the process should be. A lot of organizations set up these policies, but don't take time to ingrain the finer details of these policies to their employees. So if employees know that you don't have to be the victim, if you witness a situation, you need to report it. Now, there's a confidentiality aspect of it. We also don't trust the system in some cases that even if I report, will anything be done about it? And if anything is not done about it, will I then be victimized because I reported? So there's a whole lot in the value chain that needs to be addressed. But if people have trust, and I mean, there's a serious trust deficit when it comes to reporting and dealing with sexual harassment. And also with, so if you flip it the other way, if a man is being sexually harassed, he feels if he reports, he'll be thought of as a weaker man. So there's that culture around that as well. So there's a whole lot because there's additional confidentiality issues because people don't believe that if they report, it will be dealt with one and then it will be kept confidential and that there wouldn't be an outcome. So if we cure the trust deficit and invest more in educating people and implementing those things properly, perhaps we will get an upswing in number of people that report this issue. People will trust that if it is reported, something will be done about it, and the situation will change. Then, of course, more people will report. And if people also know that they don't have to be the victim to report, witnessing an event means you can also report. Then, perhaps the organization needs to start thinking about having diverse lines of reporting. Emails, secured line, whistleblowing policies, and all of that. Then we will probably get to a better landing space with them.
Thank you very much.
Yeah, the issue of harassment, in the workplace, it's something that you could say it boils down to culture as well as the fact that it is a lot of people don't think it is something they should report because we don't have that culture of saying something like Ose said and saying something. Harassment in all its forms, it could be sexual harassment or bullying, as we know. Bullying, for instance, is an area that I've done extensive research. I remember when we got that grant at the University of Lagos, my colleague and I, to do that research. We discovered, when we're interviewing people, workers, HR people, leaders, and employees, a lot of them, when we told them acts that amount to bullying, they were shocked because according to our culture, if an elderly person, someone in position shouts at you,
it's normal.
It's normal, or a religious leader, your pastor, people, your boss may be so angry with you that whatever is in front of him, like maybe a pen or a book, he might even throw it at you, and you still say, "Oh, sorry, sir." you know that kind of cultural thing. So people actually were like, "So this is bullying." Even giving you more work than that is above your capacity is a form of bullying, and a lot of them did not know that was the situation. So that's one of the reasons why. And then when it comes to sexual harassment, it's also a very difficult area. A lot of times, the victims, they are even blamed. Oh, what were you? Or even rape, for instance. See what happened in Unilag now that is all over the place. Something came out from management because there's a case in court now involving a colleague of mine, about raping somebody, a student in his office. The matter has been in court for quite some time, since last year. And then UNILAG came up with this write-up and said, "Oh, these are the things you should do to prevent you being raped." And who is it addressing? Women, the victims. Oh, do not wear this kind of clothes. Do not take drinks from men. They are not even addressing the problems about victim blaming. What were you wearing? You even report to police. They say, "What were you doing there? Why were you alone with this guy? What were you wearing?" you know, and things like that. So because of that, you see that people would rather not report. Then organizations don't make it easy. When you talk about putting policies there, such that, for instance, it's okay, we have a policy against sexual harassment in this place. And if you are being harassed, you must report. Put that in place practically. And then let people see that, look, there will not be retaliation against you. In Canada, in the US, in many European countries, it is a law, it is a must that you must have sexual harassment policy in place. You know, it's a kind of new in Nigeria. We don't even have a sexual harassment act per se. The only act that was put in place hurriedly was the one against sexual harassment in tertiary education, you know, because of that BBC case. And when you do that kind of fire brigade approach, it doesn't work. There's sexual harassment everywhere. So we should have the Sexual Harassment Act. And I know many multinational organizations from my research have sexual harassment policy. But the case that my distinguished colleague mentioned earlier, Ejike's case and Microsoft, you see that even though back in their home country, they have sexual harassment policy, and that is supposed to apply to their subsidiaries anywhere in the world. You see that the way they took that case, this woman reported sexual harassment. And the normal thing is that when you report sexual harassment, you must investigate. There should be a grievance procedure, and you must do something about it. The man had threatened that if you report, nothing will happen and I will fire you. And that was exactly what happened. That was why she joined the Microsoft here, along with the Microsoft in Nigeria. And that judgment was in her favor, even though we didn't have a sexual harassment act then, and we still don't have, as far as I'm concerned. NIC had that power by virtue of Section 253 to judge according to international best practices and international labor standards. So they were able to judge in her favor. And luckily, she was able to prove, because the man had harassed other women. That's some of the details of the case in that workspace. And she got judgment in her favor. I think about 30 million naira at that time, which I think was small money considering what she suffered in the process. So a lot of organizations don't have a sexual harassment policy or any form of harassment policy within the organization. And then and when you talk about policy, you must have the procedure, the grievance procedure to go through with it. So that is why it is something that is still not being addressed properly within the Nigerian workspace.
I think there's a lady, someone has a hand up, Ediko Michael.
Yes, please go ahead. You can unmute, introduce yourself, and ask your question. Ediko Michael.
Okay, can you hear me now? Can you hear me?
Yes.
Okay,
Yeah,
so
we can hear you.
okay, you made mention of this statement, giving more work than your capacity could be a form of bullying. And I would like you to please throw more light on that statement, because my head went to a whole lot of scenarios in my company. And what do you mean by the person's capacity, and what do you exactly mean by more work? Because a lot of persons could go under that umbrella of, oh, I cannot do this, or they could use it as a form of being lazy. So please, I'd like more clarity on that statement, please.
Okay, Deacon, that's I understand where you're coming from. So some other persons have also commented on that. That's Daniel. Say, wow, so giving somebody work above his or her competence or capacity is a form of bullying. Yes, because if by the time we employ people during the recruitment process, you get people's resume, you've seen what they've done before, and you know what they are competent to do, what they have capacity of doing. And so it is expected that when they get that job, you know exactly what they can do. So when you give somebody more workload or kind of work to do that is above that person's competency, you know that that person is not going to deliver. If you want to make people do more than what they are competent to do or what they are assigned to, they have assigned to do, then you must train them to that level. That's what a lot of us don't get. Under common law, incompetency, looking at the opposite, is something that can lead to summary dismissal. You can dismiss somebody because of incompetency. And we've seen cases like that, even from 18-something Cornelius, Hammer and Cornelius, who claimed to be an artist, brought his work during the recruitment process. This is what I have done. And after employing him, okay, reproduce even what you said you have done before, and the person could not do that. Obviously, it wasn't that person that did that work. Also, it applies when you talk about somebody being given more work than the person is competent to do. You, as the employer, should know what your employee is competent to do. If you employ somebody as, how would I put it now? What kind of example can I use again? You employ somebody as an office assistant. I don't know whether the definition of office assistant as we have it in the university sector is what they have in the corporate world. And then in UNILAG, for instance, an office assistant is somebody who cleans the environment, and sometimes you send on errands like, okay, go and deliver this mail in this department, go and deliver mail in that department. And then suddenly you now say, okay, sit down, take up notes, make these recordings for me and all that. You are giving that person more work than that person is capable of doing. The person will be like confused. Is this person trying to get me out of this place? The person becomes overwhelmed. That's a form of bullying, because you are now making the person do what that person does not have capacity to do. I don't know if that example is a good one and makes the point.
Okay, yes.
Question. Oh, sorry. There's another question in the chat box from Vivian. She says, Dr. Danasi, you've acknowledged that institutions have a role in shaping culture, not just responding to misconduct. How then can universities and employers communicate practical safety advice without creating the impression that that burden of preventing sexual harassment rests primarily on women? Is there a better way to frame these messages so that they promote consent, accountability, institutional responsibility, while still encouraging personal vigilance?
You can frame it in a better way. I use the example of the topical thing that is going on at the University of Lagos, because it's focused mainly on women, which even amounts to discrimination. You are removing the perpetrator of rape, because the message is about rape. If you don't want to get raped, these are the things you do. Then you ask, what of babies that are raped? Or you go further to places like Saudi Arabia, if it's about what you wear, which was also in that is it pamphlet or leaflet that is circulating, if it's about the way you are dressed, in Saudi Arabia, you have to wear not just hijab, you have to wear the abaya. We all know what that means. You have to wear this long robe covering you from head to toe, and women are raped despite that. So babies are raped. If you go to what's the name of this organization that talks about that handles rape victims, they've told us about the youngest rape victims they've had is about 2 months old, and they've had women who are in their 80s that were raped. So is it about how you look? Is it about what you're wearing? No. Like I said, with the Saudi Arabia example, women are covered from head to toe, and you still have incidents of rape in those communities. So it's not something you should just direct at victims or women who are being raped. You have to also let men understand that no is no. That should be part of what you are putting out there. Like UNILAG should have put it out there. Say, okay, anybody who wants to rape, I know. We say, okay, men do get raped too, you know. Or men in this space may say that, but you must ensure that you say no is no, whether you are a man or a woman, whoever is being. If somebody, even if a woman follows you out, you say, let's go for lunch. Because men in Nigeria, people think that when you invite people out, it automatically means because I'm going to pay for this food or whatever, then I don't even need you to say yes. That is wrong. Recently, I saw something on social media. The guy said, look, even if you are about to start the thing, the act itself, you are even in a room and the woman says no, and it was a man that was saying this, and the woman says no, stop. No is no. Even if she had consented before and the reality dawns on her and she now says no, you stop. So all these things should be part of the messaging. Everything should not be directed at the women. Oh, don't wear this, don't be alone with the man, don't do this, don't do that, don't do that. That was what we were told thousands of years ago when we were growing up. When I say thousands of years ago, I mean a long time ago. My grandmother told me that. And the first time I visited my husband, the man who is my husband now for 45 years, I didn't go alone because we were told never to go alone. I went with a friend of mine to visit him, and he was like, oh, why did you come with your friend? You know, but now I think everybody should be so educated to know that, look, even if I'm going to visit you alone as your new girlfriend or whatever, it doesn't mean that, you know, if I say no, we have to continue. So the point I'm making here is that the whole messaging should not be directed just at women. Men should also take responsibility. You should also let the would-be rapists know that no is no. And that when you are in a power relationship with somebody, a student and a lecturer, that's power relationship. You should not use your position to intimidate a student. You should not use your position to intimidate your female employee or your subordinate. Or it could be a female harasser in the workplace. Maybe you are the boss to that your male subordinate. You should not say because you are the boss, you should use your position to do that. That's why you have those policies have to be in place. You know, I know UNILAG has a sexual harassment policy. During the time of Professor Bello, that was done. So that's what I can say about that issue that was raised by Vivian.
Thank you very much. Thank you. Thank you, participants. Thank you, Ms. Opeku. Thank you, Prof. Danasi. You've given us an insightful and practical presentation. we have key takeaways. So on behalf of ELAN, I want to say thank you again to the participants for a very engaging discussion. We've now learned through this presentation that the topics today are not just HR issues, they are legal issues. So once again, amazing session, very engaging. And I believe there are no other questions. I'll hand over to our host for today. Fatia, are you on the call?
Yes, I'm on the call.
Over to you for your final words. Thank you.
So on a lighter note, I think an instance of us acting out is the
Sorry, we can't really hear you.
Hello, can you hear me?
Yes, it's a lot better now.
Okay, so an instance of acting out is what Ellen has done by calling for two speakers to handle this session. That's our own little way of contributing to the DEI discussion. And we thank the speakers for giving us their time despite the difference in time zone. We appreciate it. And I'm sure the participants have one or two that they've learned from this session. For me, I've learned the different forms of workplace discrimination and then the gaps that we have in our legal framework and how we can be better so that we can contribute to the international best practices. For the slides and the recordings, they'll be shared with the participants too, and we do not take their time for granted. Thank you so much for joining us.
Thanks.
We look forward to another session with you people joining. You can also join us. You can follow us on our social media handles at official ELAN. Thank you so much and have a great day ahead.
Thank you. Thank you, Fatia. Thank you, Ms. Alpeku. Thank you, Prof.
Thank you.
Thank
Thank
you.
you.
Thank you, Alicia. Thank you, everyone.
Thank you. Thank you all. Have a nice day.
Bye. Bye. Bye, everyone.